Welcome to Future Consumer ADR, a podcast where we discuss what's happening and what's next in consumer and mass claims resolution. Hear from experts in their fields on the latest trends and innovations in consumer and mass arbitration, litigation, and beyond. My name is Adam Shoneck, host of this podcast. I am Vice President of Business Development for the American Arbitration Association. I've been with the AAA for 15 plus years, nearly all of which has been in the consumer space. Today, I'm joined by Dr. Annekatherin Schmoll, an attorney with Gibson Dunn in Frankfurt. And our topic of discussion is consumer mass claims resolution in Germany. So welcome, Anna.
Hello, Adam, and thank you for inviting me.
Absolutely. Could you tell us a little bit about your expertise and background?
Of course. As you said, I'm a lawyer here in our Frankfurt office of Gibson Dunn and Crutcher. I typically work on domestic and cross-border arbitration, but also on litigation. And I'm also part of our enforcement of arbitral awards and judgment group, helping to enforce such titles around the world. I've advised one company in one of the model declaratory action, which is relevant for our topic today here in Germany. And I'm also involved, beside that, in the arbitration community internationally, but also in Germany. I'm the co-chair of the DIS, of the German Arbitration Institute here in Frankfurt. And yeah, that's who I am.
Okay. So what I wanted to talk about, just to set the background, is what is the general stance on consumer protection when it comes to EU and German law?
Yeah, totally. So before we step into the topic, I would like to clarify the thing
Sure.
between EU law and German law. Makes sense, maybe. So first, because there are two paths from a EU level. So first, you have like EU law, and EU law has always premises over national rules. If German law conflicts EU law, the German courts must set aside anything in Germany and must apply the EU law. Second, there are two main instruments which come from Europe, which means you have the regulations. First, what is a regulation? It applies directly and immediately in all member states. And then, what is important for today, there are directives, and they only set goals and minimum standards, and each member state has to implement it through their own law.
Okay.
Where such a directive allows a minimum harmonization, member states may go beyond EU law, which happens always a lot in Germany.
Okay.
And there are other directions who provide for full harmonizations. There it's not possible. But what we are talking about today, it's about minimum harmonization directives.
Okay.
Yeah.
So
yeah.
Go ahead. Sorry.
No worries. And the topic of consumer arbitrations, actually, first, it's quite easy because under EU law and German law, they exhibit both caution toward consumer arbitrations. Under the EU Unfair Directive, courts are instructed to treat a non-negotiated arbitration agreement as unfair term. And it's also part of the public policy why such arbitral awards could be nullified immediately.
Okay.
And the German law even goes beyond. This is what I said. They implemented in the German Arbitration Act, which is part of the German Civil Procedural Code, one rule in 1031, paragraph 5. And this provision provides for that if a consumer should be part of an arbitration agreement, the arbitration agreement must be contained in a separate document personally signed by the consumer. And this document is not allowed that this document deals with other contractual issues. There is one exception if this contract is notarized, but honestly, no consumer has contracts typically which are notarized. So
Right.
in a nutshell, arbitration clause has to stand on its own, clearly and explicitly agreed by the consumer.
So it almost never happens, is what you're saying, right? That they don't, no consumers actually sign these forms, and even if they were pre-dispute, they wouldn't be enforceable. Is that right?
If you do not fulfill the form requirements, which are quite
Okay.
strict. And that's why, and there's another hurdle actually, and there are some areas of law which are not arbitral under German arbitration law. For example, residential leases, you never can arbitrate, no matter in which contract. And for example, labor law disputes or disputes under German security trading acts are not arbitral for consumers as well.
Okay. Um, so how do mass actions in Germany get resolved, consumer mass actions?
Actually, there are avenues I could describe
Sure.
because it developed over the years because there were no big consumer actions in Germany, but it developed since some big things were going on in Germany. First of all, Germany also before court does not have a US style class action. So we don't have class actions in Germany, but there are other tools consumer and their lawyers found to ask for their right. Traditionally, what happened? Hundreds and thousands of consumers filed single litigations against companies. And why did that happen? And why did it happen that easily? Because in Germany, typically, every consumer, or a lot of consumers, have legal protections insurance contracts. And the thresholds for these insurance companies do not grant the coverage for a case is very high. So if you have a case, you ask your insurance company, and this insurance company is forced to grant coverage, and you can file a lawsuit. And this is something the lawyers on behalf of the claimants experienced and saw, okay, this sounds quite like quite a good case. And that's why we saw hundreds and thousands of individual claims, which not only led to overburdening of the companies, but also for the courts, in particular for the courts in Germany, because they don't have these legal tech tools and whatsoever. So this was is still terrible for the German courts.
Sounds
And
like it,
yeah.
that it would be a huge headache to try and manage all those cases.
Yeah, it's terrible actually, and that's why other cases, that's what courts say, were also you waited and waited because there were so many single individual claims, but they have to be treated like every litigation. So there was no tool to help here. And what happened in this regard in 2024? There was something implemented. It's called the leading case procedure before the Federal Court of Justice. This was an idea first to help in these individual claimed proceedings, because although these claims are identical, there was no tool to wait until there is one ruling because before the Federal Court of Justice, and you couldn't stop your individual case. But now you have like this leading case procedure, what means if there is a case before the Federal Court of Justice, and then the Federal Court of Justice can say, okay, we take this case as a leading case procedure, and then there will be a decision in that case, even though claimant or respondent withdrew the claim or, for example, settle, no matter what. They
Okay.
rule on a legal issue, and this ruling is not binding. However, the higher regional courts and the local courts, if there is a ruling of the Federal Court of Justice, they typically follow what the Federal Court of Justice said, although there is no case law as you know it from the US.
Understood. Okay. So they take a lead case and then typically that helps resolve all the rest of the cases once that's been decided?
Yeah, actually. And it
Okay.
could also stop or help the insurance companies at some point because they can say there's no coverage if there is some relevant case law which comes from the Federal Court of Justice.
So it sounds like the insurance companies are almost like litigation funders in this regard, that they're backing this litigation. Does that sound accurate, that they're sort of
Yeah, but you need to have the insurance contract before you knew that there was a claim, and they are
right?
forced to take the claim, the litigation funding, so to speak. But it's no funding which is on a willingly basis. They are forced
Okay.
to to grant the
Okay.
coverage. Yeah.
Is there any other litigation funding in Germany? Does that play a part? Is it legal? What kind of cases are they funding, and why are they looking for those cases?
Yeah, there are actually legal funders in Germany. So we see them typically in other areas, also like in big arbitration cases, enforcement of arbitral awards, as you also know it from the US. And in Germany, there are some cases which are funded, but the funders, they are only looking for huge cases, right? With huge amount in dispute because they want to earn something. So I will talk later a little bit on this because there is also a private mass claims assignment model in these cases, which means, or maybe I explain it now, this is
Sure.
another route you can take. You have a small claim and it came all with legal tech companies. For example, it started with tech companies. They saw that there are always the same claims like air traveler claims again for delay or whatsoever. It's always 600 euros. And then for a consumer, it doesn't make any sense to go to court for 600 euros or even to send a letter to an airline for 600 euros because it's for some consumers too much work. So what they opened, for example, they opened a web page. You can assign your claim to the web page, and they are checking, for example, if if your claim is eligible, and if this claim is eligible, then for example, Flightride, and there are other of these legal tech companies, they sell your claim.
Okay.
um, and then they are the new claimants, and then they bundle these claims and go to the court. And then since then you have the bundled claims, and this is more interesting, I would say, for third-party funders because it's a huge amount in dispute.
Got it. Okay, that's really interesting. I don't know that we have anything equivalent to that in the US. So that's interesting. And you did touch a little bit on legal tech, but what sort of legal tech is becoming popular in Germany, and does it impact consumer claims in any other way aside from the bundled claims?
Actually, what I described, this legal
Hmm.
tech, this was a boom. It was not only about flight ride. There were whatever my ride and lease rights for everything, which is somehow standardized. You find a legal tech company with lawyers, and they combine legal expertise with legal
Oh,
tech. So it's quite easy. You just sign up, enter into your claim, and then they say, "Oh, looks good." And you don't have to pay anything until they receive something from the company they sued or maybe only send the demand letter to, and then you can, and then they say, okay, and now I have 25 to 30% or something, and it's for me.
Okay, very interesting. Do you see what do you see coming on the horizon for consumer claims resolution, in the next 5 years or so?
Yeah, first, there are what we are checking are the all consumer action phases we have in Germany. So we are checking the model declaratory action we always also have in Germany since 2018, which unfortunately is not that prominent. I think we only have since then 30 or 35 cases, which is nothing. Which is, I think, why is it the case here? It's all about, again, about the legal protection insurance companies, because for the lawyers who represent the claimants, it makes more sense to file individual lawsuits, earning per individual lawsuit, instead of filing one model declaratory action, because there is a fee cap for the lawyers who represents this consumer protection group. So that's why there's not too much advertisement for these. There are only declaratory actions if in areas where there are not enough insurance companies in place to unfortunately have to grant the coverage to their consumers. And however, what we see actually also, we have like representative actions. This is something which came in 2023. And the representative action, it goes back to a EU directive. And the idea is now not only to have a declaratory ruling, like you have it with the declaratory action, but then you have like a redress action, and you can ask for damages or whatever relief for the consumers, actually. And there is also no restriction. You can file a representative action in every area, but you only need 50 consumers, but there is an opt-in mechanism. So which means you need to proactively opt in to be part of these proceedings. It's also the same with the model declaratory action, but the outcome of the model declaratory action, actually, it's only declaratory relief, which means afterwards a consumer needs to file again a lawsuit and asking for the money. And
Got it.
yeah,
Okay.
that's something what's going on. And what we see, of course, in the EU and Germany, big tech litigation is coming up on the horizon. I think this is something, also data protection issues, AI Act, all these things of issues could be issues in the future, because there are so many new regulations. And what happens if you have new regulations? There will be also some issues, and someone will find something and help actually consumers and tell consumers what they should do and how they could fight for their rights. Yeah.
Well, thank you. Was there anything else you wanted to add before we adjourn for today?
No, that's, I think it's fine for me. And it was very interesting also because I also checked how things works, of course, in the US to have a better understanding, even better understanding. And yeah, again, thank you for inviting me.
Absolutely. Thank you to our listeners for joining us for this episode, and hope to see you on the next one.
Bye.